Today's courtroom drama isn't just about drugs and legal jargon. It's about a woman who's been to prison before, claims she's turning her life around, and is now back in front of a Texas judge on a state jail felony. We've got heroin, years of addiction, for kids adopted out, and a police report that paints a very different picture from her new church-going lifestyle. The stakes? A deferred adjudication deal that could keep her out of prison if she plays by the court's rules. But as we're about to see, her idea of rehabilitation doesn't exactly match the judge's reality check. Watch closely, because this judge has no patience for half-truths or backpedaling. You're about to witness the moment where courtroom patience runs out, and the consequences get very real.
Attorney Bill Simmons for defense.
And are you Miss Ashley Hernandez?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Hernandez, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, who's in the, off the record, who's that back there?
It's my client.
Oh, sure. Okay, no problem. Oh, no problem. All right, did you understand, we're back on the record, did you understand that you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not this case should be held over for trial?
Yes, ma'am.
This is one of those moments casual viewers might gloss over, but legally, it's huge. The judge is making sure Ms. Hernandez knows she's giving up her right to a grand jury and trial prep time in exchange for a plea bargain. These waivers aren't just paperwork. Once you say yes on the record, you can't later claim you didn't understand. And notice the judge double-checks every step. That's to make sure any appeal later can't claim lack of understanding. It's procedural, but it's also the court protecting itself from future legal headaches.
Did you understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Application for Deferred Adjudication. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you the information. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Counsel, are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would just pray that the court follow the plea agreement.
All right. Ms. Hernandez, when's the last time you were employed?
Like 4 months ago.
Doing what?
My dad has he owns a lawn care.
All right. What's the name of this person you were with?
Like working.
No.
Jack
And the police report.
Some homeless guy that I was out there with.
All right. Just off the record for a moment. So on this, instead of putting this in here, if you just say that he was in, yeah. Thank you. All right. We're back on the record.
It was just some random guy. I was homeless at the time.
That right there is a red flag for any judge. Ms. Hernandez admits she was homeless and with an unidentified man at the time of the offense. In the world of courtroom credibility, vagueness is dangerous, especially when it comes to drug-related charges. The more you can't explain, the more the court assumes the worst. Here, she doesn't even try to downplay it. She just says, some guy up the street. That doesn't exactly scream stable lifestyle ready for probation.
It was just some guy up the street. user.
Okay. Do you have any children?
Yes, ma'am.
How old are they?
I have a 17-year-old, a set of twins that are 14, and a 13-year-old.
And where are they?
They've been adopted. They've been out of my life for, well, I'm gonna say pretty much all my life.
Okay. How often were you using?
I was using for at least 10 years.
Okay.
I've been clean for almost a year already. I was using heroin.
Well, it can't be almost a year because we're still in
Barely going off like.
all right, because we're still in 2023. Am I right in that?
Yes, ma'am.
And this offense was April 3rd, 2023. So you haven't been clean for a year.
It's going on a year.
And here we have the first real collision between Ms. Hernandez's narrative and the facts. She proudly claims she's been clean almost a year, but the judge immediately checks the calendar and reminds her the offense happened in April 2023. That's barely a few months, not a year. In court, credibility is currency, and right now, hers is getting devalued fast. When your timeline doesn't match the court record, expect a reality check like this one.
Right. I mean, a couple months, I guess.
Okay. All right. This is what the court is going to do. Court is going to sentence you to a $200 fine that'll be probated. I'm going to want a TAP evaluation. Follow all TAP recommendations. Sorry. Follow TAP recommendations. If they recommend inpatient treatment, she needs to go to inpatient treatment. And that's to be followed by felony drug court, 4 years deferred adjudication, 150 hours of community service restitution.
This is where the deal gets real. 4 years deferred adjudication, $200 fine probated, TAP evaluation, possible inpatient treatment, no work with minors or home health care, community service, and strict probation reporting. For non-lawyers, deferred adjudication means no formal conviction, but one slip-up and the full sentence can come crashing down. And the TAP evaluation isn't a suggestion, it's the court's way of determining if she's ready for treatment or needs a stricter environment. Translation, she's on a short leash.
The TAP evaluation is to take place in custody. Proof of employment within 45 days of release. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. We'll do the UA hotline until further notice. Field visits 1 time per month until further notice. Probation, is there anything else she needs?
No, Your Honor.
All right, is there anything else you need from the court to be successful?
Judge, she has a job, I believe, outside. But the real question is just, do we know about how long the TAP evaluations are taking right about now?
Probation, how long is TAP? 2 weeks.
Would the court consider? Well, I don't know. Would you like to explain to the court why you feel like you need to be?
Honestly, because me being sober living and my dad being back in my life, he's helping me get back into church, and I wanted to be a part of this ritual. This what is it called? It's like a woman barrier, and I wanted to go on this retreat so I can cleanse myself and actually.
Okay, let me ask you this. This retreat, does that retreat happen every year?
No, it's just like one time. It's just one time.
Like they only have it one time forever.
No, ma'am, but
This is where her rehabilitation story takes a sharp left turn. Ms. Hernandez requests to attend a women's retreat, something she claims is vital to her recovery. The judge's response? The firm no. Why? Because in the judge's eyes, addiction recovery isn't about retreats. It's about structure, accountability, and compliance. The judge even references the police report, heroin and all, as the reason she's not buying the spiritual cleansing pitch. It's a classic example of court priorities versus personal wishes.
Honestly, this is what I signed up for. So I've been living with this lady and I told her I honestly would be there for her. Like, and she's
All right,
my
so
support. I'm not
here's
lying.
the thing. I've read the police report.
Yes, ma'am.
There's heroin and everything else going on with you.
Yes, ma'am.
So no, the answer is going to be no from the court. You're going to do a TAP evaluation in custody. And if they recommend inpatient treatment, you're going into inpatient treatment. Do you understand?
Yes, ma'am.
All right. Have you been to prison before?
Yes, ma'am.
For what?
For intent to deliver.
All right. And so felony drug court is not going to accept her. So we can take felony drug court off the list and do a gang evaluation. What is the tattoo on your chest about?
Jesse? It's my ex-boyfriend. He passed away. I put his name. It's Jesse. That's it.
Okay. We're going to do a gang evaluation and we're going to remove felony drug court because with the intent to deliver, felony drug court is not going to accept her. You understand?
And just like that, the decision is made. Ms. Hernandez signs for SAFPF, the Substance Abuse Felony Punishment Facility. It's a 9-month program, 6 months of treatment, 3 months of aftercare, plus a waiting period before entry. The alternative? A motion to revoke and possible prison time. In legal terms, this is a lifeline, but only if she uses it. Cases like this highlight the tug-of-war between personal recovery plans and the structured demands of the court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Okay, here's the thing. You have a drug problem.
I
That's why
understand.
we're here.
I understand, ma'am.
And you've been to prison before, and so you still haven't gotten your life together. State has offered you deferred. People want
I'm trying right now.
to write their own program. Guess what? If you could write your own program, we wouldn't even be here because you would have written your program and you would have been successful and you wouldn't have been with some random guy that you don't know and y'all using random drugs.
That was the first case, ma'am.
Showing you that's what's in the police report for this case. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
She just had like a appeal form. So she
Yes.
follows up the agreement.
All right. So here's the thing. I don't understand why I'm getting pushback in the attitude. Here's the thing. If you want to, you can withdraw your plea. In exchange, I will send you to the state jail facility. You can do your time, you can get out, and you can again try to write your own program. You understand? All right. So the Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
This is where the judge drops the hammer. If you could write your own program, we wouldn't even be here. That line cuts through any defense argument in seconds. The judge is essentially saying, you've had chances before, you've been to prison, and if your way worked, you wouldn't be in front of me now. Judges see thousands of defendants, and they're quick to spot the difference between real change and convenient excuses. This moment? It's the court making it crystal clear that the defendant is not in control of this process.